Okay, so it's a few minutes after 7, and I think we will get started now. Thank you to everyone who registered and also is and now signed on to our webinar. My name is Nadia Steinzer. I'm the Eastern Program Coordinator for Earthworks, and Earthworks is a national nonprofit organization that works to protect communities and the environment from the impacts of energy and mining, or as you could see here on the slide, mining, digging, and drilling. We've been around for over 25 years in different forms, working directly with communities, stakeholders, and policymakers to bring about better protections for frontline communities and for air and water. I've been working as Eastern Program Coordinator for about 6 years. I'm based in New York and work a lot across the Marcellus and Utica Shale region. So thanks again for joining the webinar. Really appreciate all of your interest in this topic. For the first several years of the shale gas and oil boom, both proponents and opponents were really focused on production. And while drilling and fracking are still very big concerns, we've obviously moved into a new phase of the development, which is the rapid expansion of infrastructure. And here tonight to launch our webinar series on this program, on this topic, excuse me, is Lynda Farrell and Carolyn Elefant. And I'll just give a brief introduction to the topic and to them, and then they'll get started. So by infrastructure, we really mean everything that supports oil and gas development as a whole. This includes pipelines, compressor stations, gas to liquids plants, storage, waste disposal, power plants, and much more. All of these are, in effect, different spokes in the oil and gas development wheel. The industry is increasingly transparent about the need and their intention to vastly increase processing and transport capacity, which is what they feel is necessary if they're going to continue to produce and profit from oil and gas and be able to move it to major markets. Dozens of new projects have already been proposed and many new facilities are being permitted and constructed. So even if you live in a place without drilling, chances are you'll be affected by some kind of oil and gas infrastructure. Awareness is growing about the land, air, water, health, and property impacts of so much development as a consequence of it reaching in so many new places, just as fracking and production has done and continues to do. So communities everywhere are now responding to these infrastructure projects that they face, just as they did in order to fight fracking. So even for those of us who are steeped in oil and gas issues, it's been quite challenging to get our heads around the infrastructure beast or the infrastructure wheel. Each project is planned, reviewed, and permitted separately and has distinct impacts and technology and geographical considerations. Yet at the same time, many of these projects raise the same concerns. And residents, activists, advocates, and policymakers everywhere are asking many of the same questions about impacts and what's going on. So Earthworks and the Pipeline Safety Coalition are among the organizations that frequently receive requests for information. Our organizations, therefore, are really interested in developing resources and conducting education and outreach in order to assist the communities, elected officials, and media who are working on these issues. So this summer and fall, we are jointly conducting a webinar series on 4 current issues related to oil and gas infrastructure. And other topics going forward will include air, climate, and health, the growing problem of oil and gas field waste and how it's being managed and disposed of, and then the public risk burden of all of the investment and expansion in infrastructure and what that means for the public both day-to-day and financially. But now tonight, you're going to hear about the importance of community participation in planning, permitting, and safety, and it's something that our organizations are really committed to seeing more of, and we're very heartened by the great work of so many organizations and local groups and residents in increasing public participation. So building pipeline infrastructure involves such a complex mix of regulation and oversight on the local, state, and federal levels. And in addition, gas and hazardous liquids pipelines are regulated differently by agencies and utilities. So helping us to understand this topic, as I said earlier, is Lynda Farrell, Executive Director of Pipeline Safety Coalition. Lynda has over 20 years of experience working on the interactions between landowners and pipeline operators and building relationships with government and non-government agencies, industry, and communities. She is a former farmer and educator and brings a holistic approach to pipeline safety issues. Tonight, Lynda will unravel the knot of permitting and regulation, explain the differences between natural gas and hazardous liquids pipeline systems, and explain why community engagement is so important both locally and at the state and federal levels. After Lynda's presentation, we'll hear from Carolyn Elefant with the Law Offices of Carolyn Elefant, PLLC. Carolyn has more than 2 decades experience as an energy and eminent domain attorney, including with the Federal Energy Regulatory Commission, private practices, and nonprofits such as the Ocean Renewable Energy Coalition. She is greatly experienced in litigation, contracts and easements, testimony, and other aspects of all of these energy issues. Tonight, Carolyn will discuss the differences between natural gas and hazardous liquids regulations and share examples of current litigation underway. She's also going to offer ideas for residents who are navigating the regulatory landscape and how to get involved. So a couple of housekeeping items. Just keep in mind, everyone's line is going to be muted during the webinar to make for a more comfortable and enjoyable presentations for everyone. We're going to take questions at the end of both Lynda's and Carolyn's presentations. And to ask questions, please do so in the chat box on the lower left of your GoToMeeting screen. It'll say chat there, and you can put your question there. I'm going to be gathering the questions, and if there are a lot that are generally the same, we'll ask them together. So please write in your question. If you are listening in on the phone but are not online, please submit questions to this email address. It's info@earthworksaction.org. Again, that's info@earthworksaction.org. And we will also check that email address to see if there are questions at the end. But the preferred way would be the chat box. And the presentation slides and an audio recording will be available to everyone who registered for this webinar. So if you know someone who couldn't make it, or if you have to hop off early, it will be available to you after. So thank you very much, and I'll turn it over to Lynda.
So thank you for all that help, and thank you, Nadia, for the partnership here. We are Pipeline Safety Coalition. Our relationships focus on improving public, personal, and environmental safety. We provide a high level of equal access to information, but particularly through community and government and legislative mentoring. We try to facilitate respectful and productive conversations between citizens, environmental groups, local, state, and government officials, and pipeline operators. I want to note that in this presentation, most of the photographs that I took during a Williams Transco 42-inch pipeline construction project on our personal property. Photograph that you see here is a 42-inch pipe, and I included that to indicate to all what the depth is of a typical pipeline that's placed in your land. It's about 3 to 5 feet, and although it doesn't look like it, that is a 42-inch pipe. That's that same pipe being laid. So we are talking tonight about planning, permitting, and safety. We'll talk about community participation and paying it forward, particularly legislation and involving legislators. Who regulates what gas versus natural gas versus hazardous liquids? And at the end of the presentation, I have a kind of cliff notes that'll provide you with a reference point in the future of who regulates what. So we know through experience that without community engagement, without community participation, this is what can happen. The photograph in the top right is from that same Williams Transco project many years ago, where a 30-inch pipe was was increased to a 42-inch pipe. And the straw there is not ceding their property, that is the pipeline, so right of way. So these folks wound up with a 42-inch natural gas high pressure line within 2 feet of their garage. The pipeline had been laid in the 50s, and of course the house was built without consideration for where a pipeline was laid. One of the things that is important in public participation is participating in the federal documents, the federal proceedings. In 2010, PHMSA is the Pipeline and Hazardous Material Safety Administration, put out a notice of proposed rulemaking to increase the state safety requirements in hazardous liquids. And in 2011, they initiated a notice of proposed rulemaking for increasing PHMSA's regulatory authority in the realm of safety. Just this past spring, there was a FERC docket, as noted here, and these are all hyperlinks so that you can go to them and do some more looking into them. This was a cost recovery mechanism for modernization of, there should be only one of their natural gas facilities, and it really was a proposal to increase FERC's authority over siting and to expedite the approval of projects. Pipeline Safety Coalition on that docket. It was unfortunately has passed on, but these are the kinds of things that with education and with public participation, we all as citizens can participate in commenting on these dockets. Many of you may be familiar of the FERC process that we'll talk about in a little bit when it comes to siting interstate lines. So there is currently a proposal to reissue and modify nationwide permits by the Army Corps of Engineers. And that's something that I really highly recommend folks read. Again, that's a hyperlink, and comment. The deadline is Monday, but it certainly is a very important piece of legislation that should be addressed by the public. So we also know that without community engagement, the industry very often will not tell you the things that you should know when it comes to landowner rights. And here there are a list of things here. Some of the more surprising facts are that if a house is more than 50 feet from proposed construction, the owner doesn't have to be contacted. So that's another reason why public participation is really important, contacting your neighbors and sharing your knowledge with them. The fact that temporary and permanent easements are different, they're paid for differently. The permanent right-of-way is in perpetuity, and that right-of-way is owned by the operator. The operator can pass it on to someone else. They can lease it to someone else. They can sell it to someone else. The right-of-way is subject to income taxes, so you will receive a 1099, and that you have the right to meet with the operator and negotiate as a community. There's a lot more power with a community approach to negotiating with an operator. We have on our website Knowing Your Rights down at the bottom of the page there, and we shared a lot of information with the folks at Kentucky Resource Council. They, by the way, are an organization who helped to defeat the Williams Bluegrass Project in Kentucky by gathering neighbors together and all making the same ask of the company that was just too much for the company to be able to actually agree to. And so they rather than acquiesce to the public demand, they withdrew the project. So we know that community engagement involves education and organization, outreach to each other, and that becomes shared responsibility and goals. Reaching out to legislators, who are the ones who are going to work with the public in state and federal permitting and making the changes that need to be made for enhanced safety and the enhancement of public rights being acknowledged by operators. So sometimes your partnerships are going to be likely, and sometimes they're not going to be likely. But a bridge not crossed is certainly a sad loss for the community. This is one of the reasons that landowner rights can be one way landowner rights can be enhanced through community participation. And at the top of your screen there is a blue dot that Google apparently represents my house with a blue dot. Carolyn will know about this this project. This was the Williams project over 10 years ago that brought me to much of this. What we did was we had 5 landowners who all kind of stood their ground and refused to sign easements. 8 years later, my husband and I were the last ones standing, but you can see between those arrows that the right-of-way that was given to Williams by the adjoining neighbors is about 50 feet wider than ours. For 8 years, we personally said that yes, we wanted Williams to replace the pipe with a 42 for the safety reasons, but that we knew that technically they could do it within their own right-of-way. 8 years of negotiations, but they did finally put the pipe in, replace the old pipe with a newer, better pipe, and we did not lose any of the stability of the fragile environment there. If you look to the left of the first arrow, imagine if everyone along the pipeline had done what we had done. The right-of-way would have remained a far smaller right-of-way, and certainly would have been an enhancement to the environment. So this is another example of what community participation working together can achieve. This is a data sheet that Pipeline Safety Coalition started just recently. We asked some of our partners out there to help us create a database of project status. And you'll see that the overwhelming, this began, we started collecting data on projects starting 2013. And there's an overwhelming number of projects that have either been delayed, denied, or withdrawn before actually submitting their permit applications. Now, granted, there are far more projects out there that were absolutely approved, but this is a very outstanding indication of what public participation has done in the pipeline siting process to protect the landowners and the environment. So in all of this, you really need to know the players, kind of a glossary, what the process is and acronyms. And I won't go through all of these, but these are the acronyms and the entities that most people are dealing with when they're dealing with hazardous liquids and natural gas. And you might want to take note too that that there's a good break of crude oil, the hazardous liquids designations. And as Nadia said, it's not just a pipe. A pipeline does mean all the parts of those physical facilities, the pipe, the valves, the compressors, the meter stations. And what I'd like you to note here too is that the pump stations in the top right-hand corner, we threw some stars in some of the components of the hazardous liquids and infrastructure that do not exist in the natural gas infrastructure. But it's important when you're talking to an industry or a permitting entity that you know holistically, you know what the infrastructure consists of, so that you have a holistic approach to the comprehensive impacts, the cumulative impacts of what each project brings to the table. In the diagram in the bottom left, this is the red inserts of the lines are inserts by us at Pipeline Safety Coalition. These are additional types of lines that have been added over the last, maybe 5 or 6 years to the natural gas infrastructure, particularly with Marcellus Shale, the freshwater lines and the flowback lines. These are all lines that many of them are not regulated, the freshwater and the flowback lines, for example. But we believe those are lines that, as communities with public participation, we will ultimately get under regulation as well. So who regulates what can be really confusing. Pipelines are categorized by what they carry and where they go. For the most part, FERC regulates the siting of proposed interstate natural gas pipelines. But there are no federal agencies that regulate the siting of crude oil. That rests with the individual states. As far as safety goes, PHMSA is authorized by the Department of Transportation to regulate transportation. Under the U.S. Department of Transportation, we're transporting fuel, and so just as a taxi cab or a bus is regulated by the Department of Transportation, the PHMSA, the arm of Department of Transportation, regulates pipeline transportation of both natural gas and hazardous liquids. However, those regulations differ from natural gas to hazardous liquids. And if you remember in one of those first slides, I talked about one of the proposed rulemakings from PHMSA. One of those proposed rulemakings is to increase the oversight of hazardous liquids lines and bring them closer to natural gas standards. The paragraph at the bottom is, I think, kind of a nice, succinct statement that Congressional Research Services produced. And I think when you take a chance and read that, it shows how confusing the regulatory process, in fact, is. So one of the things that you can do is, and when it comes to trying to pave your way through trying to find out who regulates what, PHMSA, and the website is up at the top of the screen next to Pennsylvania. PHMSA has a safety, pardon me, has a safety website that is state specific. If you look over to the left, you can pull down on that state pipeline profile, and you can choose whatever state. I live in Pennsylvania, so I chose Pennsylvania. And this page will give you access to everything from incident trends to damage prevention and what operators are in your area and who regulates pipelines in your area. One of the things that we found with the PHMSA CATS representatives, the Community Assistance Technician folks at PHMSA, is that yes, they are absolutely only regulating safety. However, they have a really good sense of what the jurisdictions are statewide in their regions for siting, and very often can help to connect you to the proper agency to answer your question about who regulates what in siting areas. That same website will, if you, when you're in Jersey, but when you're in that site for the choosing the state for your search of who regulates what, you can see that, for example, in New Jersey, they do have a link to statutes and enforcement programs. So these two links are very helpful in trying to parse out who regulates what. So knowing the players and the process and the acronyms are all very important. NEPA is I think a fairly universally known acronym for people who are getting into community participation of the in pipelines. NEPA is the National Environmental Policy Act, and it's a U.S. environmental law that was created to promote efforts to prevent or eliminate damage to the environment and the biosphere, and to stimulate health and welfare of man, and to establish a Council on Environmental Quality. NEPA, honestly, is purely procedural, but through the NEPA process, we're able to significantly uncover direct and indirect impacts in a proposed project. Things like the impact to the physical environment, economic impacts, and social impacts. Scoping is held early in the NEPA process to determine the scope of the issues that need to be addressed in an environmental impact study. There's a list here of a lot of the, a short list of the many areas that a NEPA scoping will identify issues, such as the cumulative environmental impacts, soil geology, wetlands, cultural resources, socioeconomic, etc. Now, generally, an environmental assessment is prepared prior to an environmental impact statement to determine whether or not that more robust review of the environmental impact statement is needed. And the things that folks want to address as a community when looking at an EIS is whether or not the statement of purpose and need are verifiable, and a discussion of environmental impacts and no action alternative. Has that been discussed in the EIS? And direct and indirect effects of a project and cumulative impacts as well. Conflicts with the objectives of federal, state, and local land use plans, which means you really want to be working with your local officials. You want to be working with your state representatives and with your planning commissions. You want to be working with your conservation district in each area. Very important too is that in that EIS, you want to be looking at ways to mitigate adverse environmental impacts. At the end of the day, the goal is most often to stop a pipeline from being put into an environmentally sensitive area. If a pipeline is approved, we certainly want to make sure that the adverse impacts to the environment and to historic and cultural resources into the community are mitigated to the best degree possible. And we find that the only way to do that is through community participation. So FERC is again the entity that reviews the interstate, crossing state lines, natural gas pipelines only. FERC has tariff authority for hazardous liquids, but not for natural gas. And we do an entire workshop on the FERC process and how to file for intervenor status. But the chart to the right gives you a sense of how that process typically flows from public input to the permitting process. And I should have pointed out in that chart of the delayed or stopped projects, there was a LNG out in Cove Point that FERC actually did deny, which was eye-opening to everyone because it doesn't happen very often. So that's siting. The safety is again through PHMSA. Congress determined that PHMSA was the agency to create minimum standards that the states could build upon, but the states have to follow the minimum standards, and the states do that by contract or agreement with PHMSA, so that PHMSA and the state together in the arena of safety. In addition to assessing civil penalties and comprehensive inspections, the PHMSA also addresses the types of materials and design and construction based on the location of a pipe and the type of fuel that is being transported. I did not, but I will before this is made available to everyone. I will provide hyperlinks to these, the Code of Federal Regulations over on the right-hand side. Those are extremely important and educational when you are looking to participate in the process. You want to be as educated as you can and follow the regulations and address your comments to the agencies that you're speaking with based on what is jurisdictional to them. And so these federal codes are very helpful in doing that. In the planning of natural and hazardous liquids pipes, obviously that starts with the operator and their preferred route. But one of the things that citizens become confused about and need to have clarification on when they're talking about the safety of a pipeline, and they're referring to the potential impact radius, which most folks commonly call the blast zone. The potential impact radius is a calculation that frankly needs to be revisited in its accuracy. You can see in this chart here, for example, San Bruno, the potential impact radius was somewhere around, let's say, 380, and the actual impact radius was 1,024 feet. It's also important to realize that hazardous liquids lines don't calculate PIR because they're liquids. They tend to seep through the ground or move through soil, and rather than become airborne because they're liquids. They're not gases. And so they don't rise to the surface and explode and catch fire as quickly as a natural gas does. This chart that Paul Rubin at HydroQuest did for us when he was investigating the Sunoco Mariner East project here in Pennsylvania is a really good chart to give you a sense of the difference between natural gas and liquid natural gas. The air is to the left, methane, your typical natural gas, and then you're down the road to your liquefied natural gases. And that'll give you a sense, rather than using a potential impact radius when you're looking at participating in the rationale of what your safety is in having a pipeline 20 feet or 50 feet or 100 feet from your home. You need to know what that pipeline is carrying and what the impact is relative to the type of fuel. So in that planning, and again, the operator is going to plan, but you also need to plan, and you need to plan your response to where a pipeline is being proposed. Along with the potential impact radius, there is consideration of the high consequence area. And the PIR circles are defined by the high consequence areas. The formula for the PIR is down below. Again, it needs to be a little updated, but this diagram will give you a sense of, in natural gas, not in hazardous liquids, what a high consequence area looks like. Now, one of the problems with high consequence area class designations is that, remember that family with all the kids' toys next to the garage, when that pipe was put into the ground, it was class 4. I'm sorry, class 1. It was class 1. It was a very rural area. And so, so when a pipeline is being planned, it's put into the ground based on the class, whether it's rural or highly populated, and therefore the I didn't find anything for disconsideration of the high consequence area, and the peer circles are defined by the items. So the high consequence area in a rural area is going to change with the development of community over time. So these are the cliff notes. The cliff notes are kind of a real easy takeaway. Gives you an idea of the definition of that infrastructure. We start with the transmission lines and classify by intrastate and interstate. Compressor stations, this gives you, and pump stations. Compressor, of course, again, natural gas, and pump stations are hazardous liquids. Each of these slides will give you an average of where they're placed in the system and who regulates them. The city gate is that place where the pressure goes down to about 3 psi and goes into the city, at which point you've got your distribution lines and your mains. And each of these slides again tells you who oversees siting and safety. So I thank you for joining us tonight, and I'm going to turn this over to Carolyn. This is our website. If you have any questions, we're always here to try to help.
Thank you very much, Lynda. And clearly there's a lot of information here, and it's a lot to get our minds around. I'm sure many of you who are on the line are dealing with these issues every day. So hopefully this was a good beginning, and as we said, the slides and this information and additional handouts from the presenters will be available after this. And again, if you have any questions, please write them in the chat and question area of your GoToWebinar control panel. And if you are only on the phone and not online, you can email questions to info@earthworksaction.org. So now we'll turn it over to Carolyn Elefant for her presentation, and then we will have time for questions.
Okay, so is my screen showing?
Yes.
Okay. All right, so good evening, everyone. I am happy to be here to speak with all of you today. I'm actually going to keep this short. Lynda did such a great job that she's actually covered a lot of the topics that I was going to discuss, so I will, no pun intended, drill down a little more on some of those points. But otherwise, it might be easier and more productive for me to just really shorten my presentation to leave more time for questions. So when I was assigned this particular presentation, I was asked to speak about the differences between natural gas and hazardous liquid pipelines, and also talk a little bit about community involvement. And so like I said, I'll touch on those briefly because Lynda has also discussed them. I don't want to be too repetitive. So as Lynda mentioned, there's differences in the types of pipelines that is going to inform various choices, such as the regulator that's in charge, the types of siting process that applies, and also whether eminent domain is going to attach and enable a company to take your property through a condemnation process in court. So I see some of these slides that maybe the, let me just get rid of that. I'm sorry, some of the formatting is a little goofy. So anyway, with natural gas pipelines, those are regulated by FERC. FERC has jurisdiction over interstate gas pipelines under the Natural Gas Act, and that's the section for it, the statute. And basically, interstate is something that either crosses state lines, or what confuses people sometimes is an interstate, a pipeline or a compressor station can be considered interstate and within FERC's jurisdiction if it is within a single state, but is part of a stream of commerce that is interstate. So many times, as you know, these companies try to divide up a project into different segments. And so you might have a situation where a single compressor station in a state is being permitted by FERC, and people will say, well, this compressor station is only in New York, it's only in Pennsylvania, why does FERC have jurisdiction? And the reason is because typically that compressor station is part of a stream of commerce. It's compressing gas that will go into a pipeline that will go to another state. So, so that's the scope of FERC's jurisdiction over, it has to be interstate for FERC to get involved. FERC also does not have jurisdiction over hazardous liquids pipelines. So basically, almost anything other than natural gas, if it's petroleum products, propane, ammonia, carbon dioxide, Keystone Pipeline was an interstate pipeline, as everybody knows, but that was subject to approval by state departments and other public service commissions because it wasn't a natural gas pipeline, and so it wasn't within FERC's jurisdiction. FERC, now one thing that becomes confusing is FERC does have authority, some authority over hazardous liquids pipelines. It's not siting authority, so FERC doesn't have the ability to permit a hazardous liquid pipeline, but it does set rates for certain types of hazardous liquids. FERC sets rates for propane, sets rates for oil, and so people often think, and sometimes pipelines even try to make the case, that because FERC has jurisdiction over the rates, that somehow gives it ancillary jurisdiction over siting. And you might wonder, well, why would a pipeline want FERC to have siting jurisdiction? The truth of the matter is it doesn't. The one benefit or the one advantage that FERC jurisdiction gives to a pipeline is the very easy and ready use of eminent domain. But that's something, that's a distinction that needs to be understood. There are two different types of authority, and when it comes to hazardous liquids, FERC has authority only over rates, not over siting. For natural gas, FERC has authority over both. So some of the implications of FERC jurisdiction is, first of all, it can potentially be preemptive, and we're going to talk about that in subsequent slides. Second, the Natural Gas Act gives companies eminent domain, and what is very unique about the eminent domain provisions of the Natural Gas Act is that eminent domain is given to a certificate holder. So when you often see eminent domain or hear eminent domain discussed on the state level, you usually hear people talking about public utilities, common carriers, serving end users. Those are some of the criteria that are evaluated when somebody is thinking about giving, when say a utility, a local utility like your local gas company is putting a gas line in and it wants to use eminent domain. So it would have to invoke state law, and so some of the factors you would look at is whether it's for public use or you know, whether it's a common carrier. But the FERC, the Natural Gas Act, eliminates all of those requirements because interstate pipelines are not public utilities. They're often common carriers because they have to put a tariff up, and so that's a feature of being a common carrier. But the statute simplifies it by just saying certificate holders. So the statute assumes that once you get a certificate from FERC, you've automatically met all those requirements that would trigger your ability to use eminent domain. So I see, and the reason I mention this, and this is going to come up later in this presentation, I see a lot of people with the FERC process arguing about, oh, it's not a common, this pipeline's not a common carrier, it's not a public utility. Those things don't really matter in the FERC process, and when you make those arguments, you're really just wasting time. They're things that are pretty clearly established. So, so that's why it's important to understand that. And again, hazardous liquids, if eminent domain applies or not, it really is very dependent on state law. And you see states have been all over the map on that. We've seen some very significant victories in Kentucky, in Georgia, where companies have tried to assert the right to use eminent domain to cite some type of hazardous liquids pipeline, and the courts have said, no, eminent domain doesn't apply. In Pennsylvania, things, with the oh my gosh, the Sunoco pipeline, that's again an issue. It's been all over the map. There have been some conflicting rulings, and so there's, it's not as clear as how that will go. So eminent domain rights on the state level are still sort of being resolved on a state-by-state basis. So some of the public participation tips, and these are things that apply irrespective of the proceeding. If you are fighting a pipeline or getting involved in a pipeline or a compressor station regulated by FERC or regulated at the state level, these are just kind of the types of general best practices that would apply. So the first thing is you want to determine what your goals are. Do you want to defeat the project? Do you want to just move the project or make it have fewer impacts? Do you want to do both? Do you want to defeat the project, have your main goal be defeat the project, but as a backup say, well, we really oppose this, but if it goes through, you've got to put it on the property line. You can't put it 2 feet from my house. So it's important to have those goals up front so that you can focus your resources on what you hope to accomplish. The second best practice is follow what I call the rules of the road. Every agency has its own regulations and its own way of doing things, and that's something that you need to understand. And the fact that you might be participating as a member of a community as opposed to somebody represented by an attorney, that doesn't excuse you from following the rules. The rules, the accessibility of the rules that you need to follow, it's different at different agencies. Once you know where to look for them, you can usually find them. And so, if you are familiar with other groups that have fought similar battles, probably the easiest way to get information is to contact them. Also, as Lynda pointed out, the Pipeline Safety Coalition has a lot of resources. The other thing is, again, and this is agency dependent, sometimes the agency personnel themselves can be very user friendly. What people don't realize in the FERC process, is that each project is assigned a project manager, and that individuals, anybody who's impacted by the pipeline, can call the project manager and ask for assistance. Some of the project managers will be very patient and give you a lot of information on what you need to do. Some of them will be completely useless, but again, it's worth reaching out to let them know that you exist. As I always say, FERC is supported by pipeline dollars, but it's also supported by taxpayer dollars, and the fact that your money goes to supporting an agency like FERC means that you ought to have the same level, or at least some level of access as a pipeline. The next thing for public participation is, if possible, locate experts, or next best thing, become experts. Many times the agencies are resource constrained. almost none of them will actually do their own independent survey studies, and you'll never see somebody from people from FERC will go out into the field and look at a site, but you're not going to see them, you know, like taking soil samples and bringing them to the lab. They just don't do that kind of thing, that level of independent analysis. So they're going to rely on the information that the company provides to them unless there's other information. And so that's why it's really important to have an expert. It's not enough to just, you know, a lot of people will, you know, a company will submit a study saying, you know, this isn't going to impact soils, or we're not going to have any impact on wells. And people say, well, this isn't true because of XYZ reasons. It's not necessarily enough to just why it's not true, you know, without any support. The better thing to do, if possible, is to be able to retain an expert who can, you know, do some studies and say, look, if you put a pipeline here, the result is going to be, you know, that there is going to be a 75% chance of contamination, you know, if you drill it this way or if you place it this way. So, you know, obviously, experts can be expensive. Many times local universities have professors or graduate students who are willing to get involved. Graduate students, I think, are a very underutilized source of low-cost labor in terms of preparing reports. The other thing is you can become experts yourselves. I have had clients who have spent a lot of time reading, you know, scholarly articles on air emissions and modeling, and they've you know, submitted some very compelling reports to FERC. They have not necessarily won the case, but at least they've gotten some information into the record, and, you know, in future cases that might be a way to prevail in a case. The last thing is that if your property is you know, it's in terms of public participation, participating in a group, getting organized into, it doesn't have to be a formal 501c3, it could be just an affiliation of neighbors, as, you know, was the case with Lynda and her neighbors when I represented them. And that's all very good, but at some point, especially if you're participating in a large group, if your property is directly impacted, your interests are going to be potentially different from other people in the group who perhaps live across town. They still oppose the pipeline, but their property isn't on the line. When your property is on the line in these cases, it's really important to have access to an attorney who can advise you at some point in the process if you're presented with an easement, or even who can, you know, give you some feedback on what types of decisions to make in the process. So I very rarely, even though I am an attorney, I very rarely recommend hiring attorneys, especially for, you know, certain phases of this process. But when it comes to your property, it's your biggest investment, and it's really important, you know, at that point you really have to look out for yourself. So it's just something to keep in mind. And then I had been asked to speak. I'm just going to jump ahead and just quickly speak about the preemption issue, and then so we can open the floor to questions. So in addition to publicly participating in sort of the main permitting process at FERC, you know, FERC is the lead agency. It's the one that gives the authorization for the pipeline. On the state level, it could be a public service commission, it could be an environmental agency. But in addition to that main process that authorizes the certificate or the pipeline itself, that approves the pipeline itself, there are usually ancillary processes. There are usually many other state agencies are involved. And at FERC, for example, when you have a lengthy interstate pipeline, it will often cross a navigable waterway, which means that Clean Water Act issues come up. The pipeline may have a compressor station, and Clean Air Act issues might come up. So Clean Air Act, Clean Water Act, and the Coastal Zone Management Act, those are federal statutes, and they basically, I guess the term is, under those federal statutes, the states are deputized to implement the federal laws. So even though you have a state implementing the Clean Water Act or a state implementing the Clean Air Act, the decisions that they make have the force of federal law, and so as a result, they're not preempted. In many other instances, state and local laws are preempted. You'll often see communities passing laws saying, FERC pipelines, we don't allow FERC pipelines in the town, or this area where or the area around the community is zoned as residential, and pipelines can't go through a residential community. So I'm not opposed to communities passing these laws. I mean, because it's a very good way to show opposition to a pipeline. But at the end of the day, none of them are enforceable because they're going to be preempted. The one exception to that is, if a state or even a locality is somehow acting under its authority under one of these federal statutes, then that action might take on the force of federal law. So yeah, and so this is the role of the states in the process. But like I said, I know I haven't touched on all of the issues, but I see it's already after 8 o'clock, and so I think it's probably best to open the floor up to questions, and I'm sure Lynda's happy to answer questions. I'm happy to answer them too if we still have time.
Great, thank you so much, Carolyn. And we've been collecting a few questions along the way, and so I will read those off, and then if folks have other questions, please put them in the chat box, as some have been doing. So one question that I'll just respond to really quickly is this question of whether the goal of public participation is to stop the pipelines or to try to make sure that they're implemented in the safest and least impactful way possible. And I think Carolyn touched on that in saying that it's important to decide your goals before you get involved, and then sometimes your goals will change as the process ensues. But it really is up to the participant to decide those goals. And I would just say too that even if it seems, even if your goal is to stop a pipeline or a project entirely, and you're forced to comment on why it should be made safer, the fact of the matter is that public participation is about industry accountability, and that make sure that they're not given a free pass in this process, and that every time you pull up an issue and you point your finger at it and you get people speaking more loudly, the accountability is increased. And I did note in that quick slide that Lynda showed of a whole list of projects. Some had really been stopped or delayed in part through the public participation process, because when it gets more difficult for some of these companies, especially in the current economic climate, they will often back down. So it's all very important. I hope that answered the person's question who asked that. So let me go to a couple of really technical questions, and I'll pass on to either Carolyn or Lynda who wants to answer it. The first one is about a project in Cincinnati, Ohio by Duke Energy. It's a 12-mile, 30-inch intra-state pipeline, and it's going through a Class 4 area, and the person asking the question says that they've sent 1,500 letters of opposition to different agencies and the Ohio Siting Board, and there are a lot of people who will be affected. It's very densely developed, 1/10 acre lots, but the Duke's president in Ohio is not concerned with public safety, and it seems that threatening intervention isn't getting anywhere. So what would you suggest they do instead? Some kind of, what would be their next step if they're just not being listened to?
So I'm trying to figure out if that is, did you say it was a gas pipeline or a hazardous liquids? Because that is, let's see, I also, I see a news story, delays controversial, I'm looking it up online, controversial pipeline plan, but I'm not clear on whether this is a Oh, okay. It does say it's a gas pipeline, so that might mean it's interstate. So it was something that would have been proposed at FERC. So generally speaking, at least if you're involved in the FERC process, unfortunately, filing 1,500 carbon copy letters really doesn't do very much, because FERC is an independent, quote unquote, independent, and in theory it's an independent agency, and it's not accountable to the public the way a legislator might be accountable. So I'm not surprised that there hasn't been a lot of response, although I do see here that, at least according to these news stories, it says that there was some delay. I guess in terms of next steps, I would reach out to the Pipeline Hazardous Management, PHMSA, to that agency, and see if there are ways, if there's a way to get PHMSA to take a closer look at the project. PHMSA rarely gets involved in pipeline proceedings, but I have had clients who have had some very good luck with getting an issue in front of PHMSA. The other thing is this is probably, even though common sense would tell you that putting a pipeline in within a few feet of homes, it's common sense would tell you that it's problematic, but unfortunately common sense doesn't always prevail. This would be a situation if you are able to get access to a safety expert, if people in the community are able to maybe put some dollars together, or maybe get a grant, or get a volunteer to get somebody to put together a safety report. That would maybe carry some weight with pipeline, with PHMSA, and it would document some of the issues for FERC. And if a report were put together, it could also be circulated to a legislator, and that might also get them to pay more attention to it. So in fact, I do have one case. It's a compressor station in Tennessee where one of the impacted community members happens to be an engineer, and he walked the length of it's Tennessee gas pipeline. He walked the length of it, taking pictures and documenting rust, holes, leakage, all kinds of things, and he put together a very lengthy report, which he filed at FERC, and the project, which had been just like zipping along, has really slowed down somewhat. He also presented the information to PHMSA. They weren't that impressed the first time around, so he got it in the hands of his legislators, and from what I understand, they're looking at it more closely. So those are just some of the suggestions that come to mind in terms of next steps.
Thanks so much, Carol, and I hope that was helpful to the person who asked the question, and just a clarification from the questioner that this is actually an intrastate pipeline, or it's being presented as. It's being presented as such, which is another thorny issue of whether it's part of an interstate plan. But I think the comments you made about the legislators and safety, highlighting safety issues, are still valid. We have a couple other questions.
Nadia, could I throw in just two things real quick?
Sure.
So I would not be terribly surprised that landowners saying they don't mind being taken to eminent domain, that they will go that far. That Duke doesn't seem to be concerned about that. That's a fairly common tactic of who's going to fold first. Also, HydroQuest, the slide that we showed, HydroQuest does that kind of study, and he's very reasonable. We're happy to talk to you folks and help you to maybe try to organize some next steps. The phone number here is 484-340-0648.
Thank you. I was hoping you would say that, Lynda. If you have any questions about specific projects, call Lynda, and you can also get in touch with Earthworks. So another question is about another specific project. It's the Stonewall Momentum Pipeline in West Virginia, and it ties into the Transco line, which is obviously interstate, but it's being presented as an intrastate project. So why isn't it being considered interstate and regulated as such?
So, and then what's the name of the project again?
Stonewall Momentum pipeline in West Virginia.
So
And
FERC has they've got, like, I don't know, they have like a lot of 3-part tests, 5-part tests for determining jurisdiction. And so usually if it always seems to be applied in somewhat different ways. Usually if something is going onto the pipeline, so if there's an interstate line that is connecting into a pipeline and delivering gas to the pipeline for transport elsewhere, that is almost always considered to be in part of an interstate system. Sometimes if the gas is coming off, depending upon the point at which it comes off, it's considered to be, there may be a point at which there's, like, what do they call it, like a break in the chain of commerce, and then the rest of the pipeline is considered to be interstate. But these are issues like that. I mean, this is an important point. If there are jurisdictional issues, those are the most important ones to research and raise. I mean, as an attorney, those are the absolute first questions I always raise, because jurisdictional issues are clear-cut, and if they're not clear-cut, they're debatable. And even courts only recently said that they will defer to an agency's view of its own jurisdiction, but they do so very skeptically. Like, if an agency is making a decision about a factual issue, if an agency is saying this pipeline, it's 2 feet from a house, we don't think it's dangerous because of X study, Y study. If you challenge that to a court will almost always say, agency's the expert, looks like they considered this issue, we're going to go with what they said. On things like jurisdiction, courts, are very skeptical, because the sort of, regulation abhors a vacuum, so to speak. Agencies always want to expand the scope of their jurisdiction, and agencies also have an obligation to take jurisdiction over something that's within their purview. So, I don't know enough about the details of this project to say why the company is treating it as intrastate, or whether it should be doing that or not. But what I can say is that would be a really important issue to do some research on and get a handle on, because if the jurisdiction is incorrect, the pipeline can't be allowed to proceed that way. So those are just things to consider. But I just, based on the facts that are available, and it's a very fact-specific inquiry is really all I can say.
yeah, and then you also have the issue where there are different segments of pipeline projects that will go up to state borders, but if they are designed to cross state borders, they have to be transparently identified as such. So it is something to poke around in more.
Yeah.
The next question we have is, I think, specifically for Lynda, to please identify what directly impacted actually means in the potential impact radius concept. So does that mean people who only have the easement, or any persons along the PIR? What is meant by directly impacted?
So I'm not sure I quite understand the question, but I think I'll take a stab at this. In a PIR, the directly impacted in a PIR would be people in the actual explosion zone. And then indirect impact would be outside, so heat, wind that creates a movement of heat, wind that creates air carrying toxins, would be indirect impacts. I'm not sure, though, if that's what the caller is asking.
Well, my understanding of the question was it's a clarification that it's not related to the pipeline easement or the pipeline route. It's related to the potential impact.
So
The radius is not based on just
the
people who are like right along the route.
well, the radius, the potential impact radius is a calculation of factors that begin at the center point of the actual pipeline. And so, again, I'm not sure I understand the question.
Okay.
The potential impact radius is a mathematical calculation of who would be directly impacted by an explosion, let's say.
Okay, if we haven't answered sufficiently, I can't see the names of the questioners, so if that person could add an additional question, we'll try to answer it in the remaining time.
Or again, be in touch, or again,
get in touch with Lynda at Pipeline
Yeah.
Safety Coalition, and we'll provide all of our contact information when we distribute the slides and so on. So another question is that New Hampshire is in the process of adding a requirement of a comprehensive health impact assessment for distinct projects. And the major argument in doing that was that compressor station emission standards did not reflect recent studies around health and peak exposures and so on. And is there hope that if New Hampshire goes through, the final process of passing this standard, that it will not be preempted by other agencies? I mean, this is an added layer of the state requiring an HIA, health impact assessment, for pipeline projects. I don't know if Carolyn or Lynda, do you want to take that question about potential preemption?
I think Carolyn might have more expertise.
So I mean, I guess first of all, if this is for like an intrastate compressor station, typically intrastate facilities often need to comply with other state laws. They may not need to comply with a local law, but something intrastate, I don't think there would be a preemption issue unless for some reason the permitting process expressly exempts compliance from a certain statute. For the federal level, to the extent that there's an interest in having this state law apply to FERC-regulated compressor stations, if it becomes part of the state implementation plan under the Clean Air Act, it will have the force of federal law. So one issue that came up in one of my cases involving the Clean Air Act was there was a state law that had said that in order to get an air quality permit, an applicant has to show that it complied with, that it had local zoning approval or otherwise was in compliance with local zoning law. And in that particular case, before this FERC certificate issued, a town had denied the local zoning approval. So the applicant still went forward trying to get its Clean Air Act permit, and the state said, look, we can't do anything. You were denied local zoning approval. Our statute says we can't act on it if you don't have local zoning approval or if you're not in compliance. So we went to court, and the company argued, oh, it's a state law, it's preempted. And I argued, no, that state law is part of the SIP, the State Implementation Plan. It's not preempted. They have to comply with it. So we did that point. Ultimately, we lost the case at the end of the day because once the FERC certificate issued, the FERC certificate was deemed to be a showing that the company was otherwise in compliance with local law. Because it was a federal approval, it preempted the local law, but that only kicked in after the FERC certificate issued. So the answer here is that if this is something that's being passed and the state follows the procedures to get it into the state implementation plan, it would have the protection. It would be considered a standard under the Clean Air Act. The company would have to comply with it.
All right, that's really helpful for any any other state considering the health impacts and looking more into the relationship with the state implementation plan. And that's actually a really good segue into the next question. We have two more in the remaining 6 minutes. The first one is, even after FERC issues a permit, is there still a possibility to stop it? What are sort of the options for rehearings and appeals in the FERC process once the certificate is issued?
Okay, so once the certificate issues, first of all, one of the things FERC has been doing is they issue certificates conditioned on a company complying with various federal requirements. So if a certificate is approved, if a project is approved, but the Clean Water Act permits or the Clean Air Act permits have not yet been issued, one of the things that can be done is to challenge those, and that's what happened with the Constitution Pipeline. FERC approved the Constitution Pipeline, so people turned their attention to the Department of Environmental Conservation's Section 401 Clean Water Act certificate proceeding, and through filing comments and leveraging political connections, they were able to get the state to deny the permit. Now that is something, unfortunately, that the company is appealing, but hopefully that's that will not happen. The benefit of that too is that because the Clean Water Act certificate, the water quality certificate wasn't issued, the company couldn't start construction. Now in Constitution Pipeline, there was a Pennsylvania component where the company did get to start construction, which was not the right decision, but if there are those outstanding state permits, it buys you time, because even though the company can arguably get on your property and do non-groundbreaking activities, they can't start building it. So that's one of the things that's most important. In terms of filing a rehearing request, I mean, if you want to bring the case to court, you have to file a rehearing. It's a mandatory requirement. FERC is taking a very long time to act on these. I had initially thought it was because they, had a lot of appeals, or now I'm fairly certain it is intentional. I'm fairly certain that FERC has an internal policy where they're basically denying stay requests, allowing the projects to move forward, and then just waiting to see if people will just say, hey, the project's built, I'm not going to take it to court, and just go away. I'm convinced that there's a pattern and practice of them engaging in that activity. But again, it's the only way you can get to court. And by the way, once a project is built, that doesn't mean you don't have the right to appeal it. As a legal matter, if FERC has done something unlawful, whether the project's built or not, the court's going to look at the issues. And in fact, in the Delaware Riverkeeper case, that was a case where the court said that FERC unlawfully segmented a project. They cut it up into little pieces to kind of conceal the overall environmental impact. That project was like 90% built, and the court still ruled against FERC. And that was on a NEPA issue, which, as Lynda said, is procedural. And so usually procedural issues are a lot harder to preserve than substantive issues. So, so those are some options. The other thing is it's very rare, but there are cases where after a certificate is issued, a company has been willing to eliminate a compressor station or move a pipeline. I don't know exactly what went on behind the scenes in those cases to effectuate those results, but I have seen them very infrequently in the FERC reports. So, it may be possible to get the pipeline to relent. Very unlikely, but it's possible.
Okay, we have just a couple minutes left until we really need to end the webinar, and I really appreciate all of the people who've hung in with us this long. Apologies again for the technical issues in the beginning. We have a couple of questions actually related to what kind of comments have the most impact, and is it better to have more comments by a lot of different people or just a few fine-tuned comments, and do FERC and PHMSA, do they accept kind of quote-unquote emotional comments, or do they have to be factual? And I'll just put my 2 cents in, and maybe Lynda and Carolyn have a really quick response, that I think we do a lot of action alerts at Earthworks. I think we all do. If maybe the agency doesn't read every one that's a carbon copy, so to speak, or that are all the same. But getting engagement from hundreds or thousands of people does influence the process. It does make the agencies pay attention and show that there's public support or public outrage over a certain project. So I would say that if you have what the questioner here is asking is an emotional perspective or a quality of life issue that you want to explain, that is certainly fair game. The really important thing, though, is to make sure that in your comments, be they written or spoken at a hearing, actually respond to the question at hand. So if if it's a citing hearing or they're asking about going through a park, probably you should try to at least respond to why going through the park is a bad idea. And you need to connect your comment to the actual question at hand and not talk about something else, even though it might seem related. I don't know if Carolyn or Lynda have anything real quick to say about that. And then we have one more question, then we are going to have to cut it off.
So I just want to add quickly, I guess I certainly agree that showing that there's opposition to the project is helpful. Unfortunately, I think that there's also at FERC a sense of pipeline fatigue. And often when you have people who, live 3 or 4 miles from a project, but it's in their community. I certainly understand being outraged by it, not wanting it in your town. But if all of the comments are from people who live far away and you don't really hear from the people who are directly along the route or across the street, it's, I guess FERC just pays less attention, may pay less attention to it. I think in addition to getting the political to getting widespread comments and a lot of interventions, if you can get an expert report in, it makes it much harder for FERC to ignore. I mean, when FERC writes its draft environmental impact statement, it can kind of say, there are 1,500 people who oppose the project. We understand that, but blah blah blah. There's no impacts anyway. But if they have to respond to like a 25-page report showing, the cultural, showing that there's an endangered species habitat along 30 miles of the pipeline that the applicant never disclosed and FERC completely ignored, that can create more problems for them and can potentially create an issue, an appealable issue down the line.
Right. So I guess the answer is really it's both and, not either or. Yeah.
Yep.
And they do need to hear that people are, upset. That's fine as well. One quick technical question for Lynda is there that the chart you showed about actual and potential impact was for a 30-inch pipeline. Does that kind of chart also exist to extrapolate impact for a 42-inch pipeline? And this is related to the Williams Atlantic Sunrise project and concerns about a school that's about half a mile away.
Sure. So the potential impact radius again is a calculation, and so the calculation is based on the maximum allowable pressure, which is and the nominal pipeline diameter in inches, the gas, the applicable to the gas that's going through that line. So all of those components of the formula would be specific to, again, the type of fuel and the size of the pipeline. So although the potential impact radius in that chart that I showed was for varying radiuses of pipes. They were not all 30-inch pipes. Ultimately, if it's the Atlantic Sunrise, yes, absolutely, the PIR could be calculated based on the formula that was in the chart in the presentation, which I'm, happy to talk to I work with a lot of folks on the Atlantic Sunrise project. So again, if you'd like to give a call, I'm happy to talk about that. But it is an absolute calculation of formula. There are no gray areas. Again, I think they're conservative. The formula is conservative, but it's what we have to work with right now.
Right, and then as that's very helpful, Lynda. And as Lynda mentioned earlier too, it gets pretty thorny with the hazardous liquid pipelines because you're talking about seeping through soil, or we all remember the pipeline accident, the Mayflower crude tar sands pipeline that ruptured and an entire community had to be evacuated. And so there's a lot of other, these are, as Lynda said, based on calculations, but there are a lot of unforeseen or very wide-ranging impacts that can occur for both people and the environment as well.
Sure, and the Atlantic Sunrise is a new project, but when you're looking at the one chart that I showed, those were pipelines that have been in the ground for a while, and we're realizing the industry and technicians are realizing that you can't use a standard PIR calculation when you're not taking into consideration the age and potential corrosion that's occurred in a pipeline, welds and things like that.
Right, so those are all the kinds of things for public participation, and never forget, everyone, that that these regulators need to have often need the facts and realities on the ground pointed out for them as well. And that's a role that I think every resident, regardless of where you live, can play. And on that hopeful note, I'm going to unfortunately have to stop this here, but thank you so much for everyone for hanging on. It's now past 8:30, and particular thanks to Lynda Farrell and Carolyn Elefant for your expertise and your time. And again, the audio recording of this webinar, all of the presenter slides, and some additional handouts will be available to you, and we will provide everyone's contact info. So if you, as Lynda invited, please call her if you have specific questions about specific projects or need resources to figure it out. And Earthworks and myself are always available to answer questions and to try to get you in touch with resources. So hope this was of interest to everyone, and please join us for the next webinar, which you'll be hearing about. We'll probably hold it in September. Okay.
Nadia, thank you for putting this together.
Yes, thank you.
Thank you, everyone, and have a great evening, everyone.
Good night.
Okay. Good night.
Good night.